Hello, very good afternoon to everyone. I'm back with this third webinar, which rather is my first technical webinar. This time I'll be speaking about some important case studies for the patent agent exam. Just a disclaimer for everyone that this is no legal advice is provided here. The entire session is only for educational purposes only, and I welcome you all on this particular. Sorry, yeah. So this is my first technical webinar online. I welcome you all for this session, wherein we'll be discussing few case studies. Actually, I would call this important case studies as far as the concepts are concerned. Beyond that, what we are also going to see is actually the way we are preparing. Since we started on the 10th of December, after that, we are preparing, each one of us is preparing for the patent agent exam. And there is a specific way by which we are preparing. We are almost halfway to all my students who have joined in for the classes. We are almost halfway, and I thought this is an opportunity to let you know where are we headed to, as well as how it is important to keep the momentum ahead. So we started in the month of December and initially discussed about the preparation strategy, basically how to prepare for each of the papers individually or independently. That is, for paper one, what should be the strategy? For paper two, what should be the strategy? Thereafter, we had a session on avoiding the most common mistakes during the patent agent examination, especially in the context of paper two. This is the third webinar. I'll call this as a Feb 22 because actually this was scheduled for Sunday, but then for some unforeseen reason, we had to push it to Tuesday on this auspicious occasion of Mahashivratri. Every month will be once at least live online, and later on we'll have a session on how to write long answer questions, because that is also something which most of the students have been asking actually, especially in the exam, how to write those answers during the given period of time. And these are the long answer questions which are direct questions in paper two, one, or at times in paper two. And finally, in April, we'll be covering a syllabus, revising the syllabus, how to revise the syllabus, that we'll be seeing in the entire series. So these 5 webinars will be online live via the YouTube channel of Pharma Literati, the one which you are here right now. Beyond that, for your preparation, we have got 5 videos of paper one that each one of you, many of you actually have gone through. But if you look at the trends, the paper one, which was for 2018, we have, of course, it was uploaded long back, but then the number of views for that are really very high. 2016, 2030, then after some gap, actually we are uploading all these videos. Paper one, all the multiple choice or objective kind of questions, those are the things which are available on the YouTube channel, Pharma Literati YouTube channel. You can access. Beyond the questions and answer, there is an explanation given because, excuse me, because at times it is very essential to understand how to write. At times we have to use that elimination method for correct answers. At times we have also to need to check what are the multiple options given and what may be the best option actually in case of that particular question. Now, beyond this, there are a lot of difficulties, or when I speak to the students, they are more concerned about paper two answer sheets. Drafting, we have been taking care in every weekend. We are drafting one particular patent application. from different technology, but then how to answer those uh, analytical or case-based questions that we are going to see in one of the examples. But then all the answer sheets for 2018, 16, 13, 10, and 11, paper 2 would be live via YouTube. The way we have uploaded it for paper 1, we'll be uploading it for paper 2 as well. 2010 onwards, all the question papers and their answers would be live. So the way we started also, I just wanted to tell the students actually the in my first session, if you remember, the one thing that I had mentioned was that you need to keep the momentum actually. And the momentum can also be kept through exams. And we have been running these exams. 26 Jan, we had mock test 1, which was for just 10% of the syllabus. Mock test 2 recently we conducted with 30% of the syllabus. Mock test 3rd actually is scheduled on 19th with 60% syllabus. Mock test 4 on 9th April and mock test 5 on the entire syllabus on 30th April. Now, through this mock test, what we are doing is actually 10% of the syllabus, which is the most important syllabus that we covered upfront, you would be repeating it 5 times. So automatically there would be 4 revisions for you for that syllabus. Same for 30% of the syllabus, you would be reading, because for every exam, I suggest go through the entire syllabus once, as well as go through all the videos for all the sessions that are provided. That way, you would be automatically revising, because keeping the momentum is the key thing. And that's the reason we are here beyond our regular Sunday sessions, basically. Now, beyond this, as I discussed, we covered drafting part, which is for mechanical inventions, chemistry inventions. So each one of you, if you have done, that's the best thing. If not, do this again. Watch the videos, take the examples, look at the question papers and how these are drafted. The process claims. Everyone faced issues when we feel process claims are easy, but everyone faced issues when we were trying to draft the process claims. We are also providing you right kind of content. We also saw the herbal and fertilizer composition, and we also had a session on the specification drafting actually. Beyond this, the ebook for the paper 2 that has been created especially for the drafting would now also include all the sample claiming strategies for chemistry, mechanical device, process and composition actually. Because if you see 2000 to 2018, all question papers, the inventions that have been asked can be categorized into 3 simple things. First, devices. That can be a mechanical device, a device from any of the industry basically. So we had various devices which we discussed during the drafting part as well. The second is chemistry, but since last 5 exams, there has not been a single question on the chemistry part. The reasoning is that actually for mechanical inventions, it can be covered by almost everyone if you know the basics of claim drafting. But that's not the case for chemistry. As a pharmacist, I'm a pharmacist. Understanding a chemistry invention and actually writing or drafting a chemistry claim is difficult. So, and it would be only done by chemists. So if I look at it a broader perspective for patent agent exam, mechanical invention for sure would be there, and a composition. Now, in case of composition, it can be a herbal, it can be a fertilizer. We had a shoe polish composition. We had a lot of pharmaceutical compositions as well. So all these things have been asked again and again actually in the exam. So one composition and one mechanical invention for sure would be there in the exam for claim drafting. There have been a lot of questions about specification drafting. Last 2 exams, 2016 and 18, didn't had a question on specification drafting. When I say specification drafting, it would involve since from the background to the example and then the title abstract claims as well. But I just want to tell everyone here, there is no specific format for patent agent examination. There can be a question on specification drafting as well. At least prepare once yourself for having that specification drafted. Reading is different, drafting is different, I'm telling you. Because when I speak to some of my seniors actually who are also preparing for the patent agent exam, they tell a simple thing that reading, analyzing, searching is easier, but the moment we see it and we have to draft, it becomes really difficult. Okay, with this background, let me now come to today's topic, that is case studies. How to understand, or the intent is not to focus on few case studies. Actually, the intent here is to let you know how to read a case study as well. Few case studies we'll be taking which I felt are important, which are also something which many of you may have thought so or read also those particular cases actually. I have a suggestion for all of you who have joined. You can put your questions at any point of time in the chat box. I'll automatically getting those questions through my link, and we'll be taking those questions at the appropriate time. We'll be discussing 4 things today. Intellectual property division at the Delhi High Court. 2 days back, the Delhi High Court has come up with the rules actually for that, and there have been questions. There have been repeated questions actually whether we should read about IPAB, yes or not. That we'll discuss here, because this is one of those ways through which litigations are done now. And this is something which is very important, neglected, I would say. There were a lot of questions earlier about IPAB, but since IPAB is dissolved, what next? Do we need to completely neglect those sections while reading or preparing? No, we'll discuss that here. Then you also will see a specific case from section 20 related to section 21. And this is actually a case which is very significant in terms of understanding the concepts or understanding the terminologies related to Patent Act. Beyond that, we'll be discussing a question paper, one specific question, analytical case-based study. 2010 question, 2010 exam will take one question and we'll try to answer it right here, because that question is something during that year almost everyone got wrong actually. And we'll lastly discuss a case on compulsory licensing. To start with, the intellectual property division at Delhi High Court, for those who are aware, those who have read, Intellectual Property Appellate Board, an appellate authority which was created in 2003 initially to hear the appeals against trademark and GI basically. But in 2007, it was extended to Patent Act, and in 2017, it was extended to Copyright Act as well. Now, April 2021, Tribunals Reforms Ordinance, through that IPAB was abolished. July 2021, there was a creation of Intellectual Property Division at Delhi High Court. And how is this significant for our syllabus actually, especially with respect to litigation? The infringement proceedings directly go to the courts. Now, till date, there were a lot of appeals that were being that were being actually done at the IPAB. All those appeals now need to go to Intellectual Property Division at Delhi High Court. A specific division has been created under Delhi High Court for the IP related cases, but it's just not about patents, it's also about the other types of IPs as well. So TM, GI, copyright and others. But for us, we'll discuss the patent related things here with respect to IPAB and what are those forms as well, because the rules have come up and now there are forms and fees as well related to for the appeals. That also we'll see. Now, the first thing, Delhi High Court IP Rights Division. We have 2 jurisdictions under the Delhi High Court IP Rights Division. As far as the Patent Act is concerned, first is the original and second is appellate. Now, original as in the first case is filed in Delhi High Court Intellectual Property Rights Division. That is under only two sections. Section 64, which is for revocation, and section 71, wherein the IPB had the authority to make changes in the register of patent. Those who attended the last lecture, for them, this is the thing that I had mentioned in the class actually. Now Delhi High Court IPR Rights Division is the place wherein you have to file file the revocation or anything that is required under section 71. Basically has to be filed at the Delhi High Court Intellectual Property Rights Division. The form for that is Form 8. Now, this Form 8 has nothing to do with your Patent Act's Form 8, basically. We'll see what kind of Form 8 this is. Beyond that, under Section 117A, which is about the appellate authority for IPAB as of the Patent Act as of now, but this would be covered under Form IX, Form 9, basically at the Delhi High Court Intellectual Property Rights Division. As I said, original jurisdiction is in cases of only section 64 revocation and section 71 for making any changes. The IPAB has an authority to make any changes in the patent register. That authority is now shifted to the Delhi High Court Intellectual Property Rights Division. This can be done through Form 8. We'll see the format of Form 8 here as well. Then we have the appellate authority under section 117A, and under section 117A, we have lot of sections actually, which can be appealed directly now to Delhi High Court Intellectual Property Rights Division. What are those sections? Under section 117A, we have a lot of things. Section 15 to 20, specific powers of controllers. The controller has specific powers, which includes, for example, this also includes the power in case of divisional applications or post-dating of the application, those kind of things. If the applicant is not, I would say, satisfied with the power of the controller or the controller's decision, you can appeal that decision to Delhi High Court Intellectual Property Rights Division now. Beyond that, section 25(4), which is about post-grant opposition. Next, section 28, mention of inventor as such in a patent. In all these cases, for example, if any of the controller gives you a decision and you are not happy, now you can appeal it directly to the appellate jurisdiction, so the Delhi High Court Intellectual Property Rights Division under section 117. Section 51, we haven't covered this, but direction to co-owners of the patent, basically. That is also something which can be appealed. We have section 54, which is patent of addition. In case of patent of addition, if there is anything, you can appeal to the Delhi High Court directly. Section 57, amendment related. So for example, if I amend the application, or if I want to make any changes to the application, and in that case the controller doesn't agree, you can appeal directly to the Delhi High Court Intellectual Property Rights Division under section 117A. What are the other things that are covered here? Section 60-61, restoration of lapsed patent. Section 63, surrender of patents. Section 66, revocation of patents in public interest. Section 69(3), registration of an assignment. We have covered this under patent register. Section 78, which is about power of controller to correct clerical errors, and lot of sections related to compulsory licensing now. Now, till date, all these sections were part of the 117A, basically, and still they are part of it, but the appeal was always to the IPAB. Now it needs to be done to Delhi High Court IP Rights Division. Now, coming back to what has been changed now is, if I go back, I'll just show you this. So we have two separate forms now as per the Delhi High Court IP Rights Division, Form 8 and Form 9. Form 8 is for the original, that is under section 64 and section 71. If you have to do appeal, then form 8 of the intellectual property rights division. It is not for form 8 of the Indian Patent Act. Form 9 is only for appellate. I'll just show you the forms actually that have been in the public domain now. And this is your first, the form 8 basically. If you look at this, this is only for sections 64 and 71 of the Indian Patent Act. And this would be something wherein you will have to provide all the details of your invention with respect to the section 64 and 71 in case of revocation, and in case of section 71, the rectification of the errors, or the IPAB's authority to make any changes to the patent register actually. Next form is form IX, which is for the section 117A in the High Court of Delhi at New Delhi, IP rights division. This is for 117A. Beyond this, why I'm discussing this, there is a reason for that, and it leads to your next case under section 21 actually. Okay. Under this now, what we have is there are sorry, we need to see these forms, as well as there's a fees that is mentioned specifically, and the fees for each of this is 10,000 rupees each. So if you have to file a petition or application made under section 64, 71 or 117A, the fees for that, be it original jurisdiction or appellate jurisdiction, the fees for that would be 10,000 rupees each. Now, these are the things that have happened in last few days, and generally the way patent agent exam is carried out every time actually, the focus has been on the recent changes basically, and that's the reason I thought I should discuss this and start with this actually. Now, what is the significance of the IPAB or the appeals basically, and that we'll see on with one particular case actually, and that is under section 21 of the Indian Patent Act. This case in 2009, Ericsson versus Union of India, it was a writ petition filed, and it was a very interesting case just to understand the concept related to Patent Act, because the terminologies, each term has a meaning associated with it. And section 21 of Indian Patent Act was discussed in this with a specific intent or specific term actually was discussed here. Now, in this case, section 21 related questions have been asked in last 2 exams actually, in multiple choice, I believe, or so. But this is something which is a unique case, and we'll discuss this in detail. The chronology is like this. There's a patent application filed in 2005 as a national phase application by Ericsson based on the PCT. Next, publication. As you know, it goes through the publication of application after some point of time. So we had a publication in 2007. Thereafter, FER. Okay, this is the exact sequence. First examination report was issued on 8th of October 2007. After FER replied within 6 months of time. FER replied on 10th December 2007. After this, everyone expected a hearing, let's say, but what happens in this case? So if you have gone through the rules or the prosecution properly, you would understand that there can be a subsequent examination report as well. In this case, there was a subsequent examination report, just SER, what we call it as. It was issued in 2008 because the controller was not happy with the kind of arguments that were actually provided, in this particular case. Thereafter, the SER was replied on 22nd September 2008. The SCR was replied on 22nd September 2008. Now, yeah. So, so after this, there was one particular date, 10th October 2008, wherein the case was kind of disposed. What is expected in this case actually is this case was disposed and the last date for putting the application for grant has expired on 8th of October 2008. That's what the controller mentioned. The controller mentioned that the last date was 8th October 2008. The application, look at the language now. Under what section the application is objected or the case is disposed? The application is deemed to be abandoned under section 21(1). Now, the abandonment under section 21(1) is the bone of contention here. Because if you look at section 21(1), application shall deemed to be abandoned unless within such period as prescribed the applicant has complied the requirements. That simply means if I don't comply with my requirements within 6 months, I'm not providing the FER reply, or with extension, let's say within 9 months, I am not providing the FER reply. Within 48 months, I'm not filing the request for examination. The application is automatically getting abandoned under section 21(1). What is wrong in this case? In this case, the disposal was based on the section 21 abandoned. That means the case is actually disposed now. But the patentee or the applicant wanted a refusal and not the abandonment. There was a specific reason for that. Actually, the court actually had this writ petition, and under this writ petition, actually, the court mentioned that it should have been refused. Actually, it should have been refused under section 15 rather than abandoned. At the end of the day, what is happening with the applicant? Eventually, whether it's refused or whether it's abandoned, the applicant may not be getting the patent, right? But then there is a procedural way actually, and that is that procedural way which was very crucial in this particular case. The applicant wanted the patent getting refused under section 15, because if they do it under section 15, then in that case, they have the opportunity to go through appellate route through IPAB basically, because this power of refusal can be appealable to IPAB. But if you look at this, section 21 doesn't have any appellate authority to IPAB. Eventually, section 21 doesn't have any appellate authority to Delhi High Court Intellectual Property Rights Division. The abandonment or refusal are two separate things. If that application is abandoned, once I miss the deadline, I cannot appeal that to IPAB or the Delhi High Court Intellectual Property Rights Division, because it's from my end actually, right? Now, but under section 15, if you have seen section 15 specifically, in that case, the application the controller has a power to refuse or amend the application under section 15. But that refusal can be challenged in the IPAB or the Intellectual Property Rights Division actually. Now, the important thing, the applicant wanted to go ahead. The applicant wanted to go ahead with the appeal procedure, and this writ petition helped them get objection, that is refusal under section 15, and thereafter the application went ahead. I think it eventually got granted as well. But what is important, why am I discussing this case? This is not a case which is highlighted everywhere actually. My intent to tell you all this is that every specific term has a meaning. If you are reading Patent Act, read it carefully. When we are discussing or when we are kind of brainstorming that point of time, it is very essential to understand the sequences basically. And what I have done here, in like for example, before the grant, there are a lot of different things. An application can be published, it can be early published, it can be examined, expedited, there can be a pre-grant opposition, abandonment, withdrawal, refusal, amendment. Everything is different. Everything has a different meaning as per the Indian Patent Act. You need to understand the differences between a withdrawal, refusal, abandonment, and amendment basically. Until and unless you understand this, you may not be in a position to actually understand the core concepts related to the prosecution basically. And that's the reason I selected this case. There was a one question actually, what is the difference between surrender and restoration? So all these things actually, lapse, restoration, surrender, revocation, post grant, all these things happen after the grant of the patent actually. And this is something very important or very crucial that we actually have as far as the Indian Patent Act. As I said, there were go through 2018 and 2016 question papers. Paper 1, there are questions related to which section is not included in the 117A basically. And the options given are, honestly speaking, it is not possible to remember every section which is there in 117A. But the exceptions, always think of the exceptions basically. If there are any exceptions, those would be asked in the exam. And this exception of section 21 was asked twice actually. Okay, I have got a question here. I'll take this question and then move on to the next case, or how to answer a particular question in the exam actually. We have got a question from Ujjwala. Our normal forms in patent acts are different from Form 8 and Form 9? Yes, Ujjwala. These forms are different. These forms, Form 8 and Form 9 in the Indian Patent Act are different compared to these forms. Look at this actually. If you go through the Indian Patent Act forms, actually these are forms for the Indian Patent Act 1970 and the relevant section. But यहाँ पे in the High Court of Delhi at New Delhi, Intellectual Property Division, original civil jurisdiction. The original civil jurisdiction is for the Form 8, and this is for appellate jurisdiction, Form 9. So these are different. The forms are different. The fees is also different. The fees in each of the case is 10,000 rupees as we discuss this. And thereafter we discuss this section 21 related case, Erickson versus Union of India. And the significance for me is because in last two exams subsequently, in both the exams, actually, this question was asked in the multiple choice question. Focus on the exceptions. That's what the intent. Focus on the terminologies, understand the differences. I'm telling you, this would help you in the first paper as well as second paper. Let us go through this interesting question from 2010 question paper. This was asked by one of my students actually a few days back, and we discussed kind of this specific question. The question is case-based. There is a patent granted in December 2009. Now the question paper is 23rd Jan 2010. Their patent is granted in December 2009. Describes and claims a process of reacting A and B under certain conditions to obtain product C. A and B are reacted under specific conditions to get product C. It is also essential that catalyst Q has to be there in order that the product C may possess the desirable characteristics outlined in our disclosure. So there has to be a catalyst Q which is very essential for that process. Those who are from chemistry would those who are from chemistry, actually they would understand, the end product, the catalyst, meaning of the catalyst, basically something that facilitates the process basically. Okay, now unfortunately none of the claims in the patent make any reference to catalyst Q. Unfortunately, none of the patent, the claims basically make a reference to catalyst Q at all, even though catalyst Q and the manner in which it is used is described in the disclosure. Catalyst Q is essential. Catalyst Q is disclosed. Catalyst Q is not claimed. Now, the question is, so your client's name is X, huh? Since childhood, these X kind of questions are very tricky actually. Like, that's what my understanding was. When I started reading this, we would like to take action in the near future against the competitor. There is always a competition for everything, and some competitors are copying your product here. What is mentioned is that a competitor of ours who has been using our process for the last 1 year, that is January 2009 onwards, they are actually because I'm presuming January 2010's question paper, since last 1 year, that means they have been using that process. Now, do you think we will have difficulty enforcing the patent? And if so, is there anything you can do to improve our prospect for success actually against the competitor? So there are 3 questions in this. This is the entire 10-mark jackpot, I would say. If you know the concepts, you can get full 10 marks here. Advise X. Firstly, as a patent agent, you are lucky that I would say X is seeking an advice from you in this particular case. Assume that X invention above has not been patented yet, but is merely subject of a patent application. So it's not granted, it's an application basically. Would your advice be different? Consider both situations wherein the application is published as well as it is still not published. Third question, assume now that the letter above is worded differently. It says that X addition of a catalyst is improvement, not included in the specification. What your advice be? 3 questions. Would there be any difficulty in enforcing the rights against the competitor? Second question, if it is not patented yet, if it is in the, I would say, if it is in the application stage, published and non-published, in both cases, what would be your advice? And third is, if that Q thing, catalyst thing, that is something improvement which he did later actually. Excuse me. I had to try to read each and every statement, try to reach each and every word actually. There is A plus B. They are my reactants. That's what we call in the chemistry. Then it gives you C under some specific conditions. And what is required is catalyst Q, which is not claimed, but it is clearly disclosed in the specification. Now, competitor is copying the process since last 1 year. Now, the first question, where would there be any difficulty in case of enforcing the rights? Firstly, what are the rights as a patentee you have got? My right is to exclude everyone else. My right is to exclude my competitors not using the invention. What is mentioned? What is mentioned in the question now? Action in the future against the competitor of ours competitor of ours, and what the competitor is doing, who has been using the process which is patented, who has been using the process basically for the last 1 year. Now the question herein is, what are the rights, firstly, and second, then can I enforce those rights, and thirdly, would there be any difficulty in enforcing? Rights are to exclude others. I'm allowed to file a allowed to exclude everyone else. Now the key question herein is, based on the information provided, whether the process of the competitor uses catalyst Q or not, that's not provided. Whether the competitor's process, whether it includes catalyst Q or not, that is not provided class in this case. Now, so the third party use is something which is not allowed for. So as a for a competitor, I can file a lawsuit basically. And since when they are doing it? They are doing it since January 2009 now. This is with respect to the factual information. Now the question first asked is whether the applicant would have any difficulty in enforcing the rights, first of all. Before that, you also need to check whether the competitor's product is infringing or not, and that is the most important key question here. If you understand the process of infringement, the way infringement is evaluated, you would understand that whether, so what is claimed? Claim has just 4 things. A plus B gives you C under specified condition. A plus B gives you C under specified conditions. Whether the competitor uses that, okay, let us presume it doesn't use catalyst Q. In that case, the competitor is actually having A plus B under specified conditions, providing you C. The product is infringing. The process that the process that the competitor is using is definitely infringing if they are not using the catalyst Q. What if they are using the catalyst Q? If they are using the catalyst Q, still it is an infringing process, because does their product contain the A as a reactant? Yes. B as a reactant? Yes. Does it give C? Yes. Does it give? Is it done under specified conditions? Yes, that's what is mentioned. Whatever you add, Q, X, Y, anything that you add is irrelevant for the determination of infringement. And the product is infringing. Now you have got 2 things with you. One, you have got a patent granted. Second, you know that the competitor's process is infringing the product. Now, what would you suggest? Do you think we will have difficulty enforcing our patent? I don't think there would be difficulty enforcing, because the moment I have a patent granted, as a patentee, I have the right to enforce my patent against anyone. I can file a lawsuit of infringement under section 104 at a proper jurisdiction, seeking an injunction, not permanent, but then maybe temporary injunction under section 108. Now, because I know once a patent is granted, I have that right to enforce my patent. Second, what is the counter argument in this case for the competitor basically? The competitor, remember, in case of processes, the burden of proof is always on the infringer. The infringer would have to prove that their process is not infringing. In any case, the claim that is granted, whether the competitor uses catalyst Q or not, is irrelevant here. Whatever they do, their process is infringing, and the burden of proof would be on them. And it would be very difficult actually to show the non-infringement, because based on the understanding of the invention and what we studied here, definitely it is infringing. right? Now, in case of an infringement lawsuit, the opponent as can counter argue that his product, the party's product or process is non-infringing with respect to the patent, or the second option is the opponent can revoke the patent under section 64. If the, and that's where this particular statement, it is also an essential characteristic basically to have that Q in the, so Q need to be there, catalyst, but it's not claimed. It's not claimed basically, but it is the essential desirable characteristics of the product would be obtained only in presence of Q. Now, based on this, there may be a ground for revocation, because as a counter argument, definitely based on this statement, the competitor can go for a revocation of the patent and go through section 64. There are two grounds, subsections, under which this can be actually, this statement, the one which is provided as information, can be used as a ground for revocation. And remember that this particular I would say application, this particular information that has been provided, based on that information, the competitor can actually go for revocation. Why I'm saying revocation? When I was discussing why not post grant opposition actually, because if you look at the timelines, December 2009 is patent granted, Jan 2010 is the question paper, and that is within 1 year the opponent can file a post grant opposition within the patent office as well. But section 64 and compare section 64 and compare section 25, there are certain grounds of revocations which are not there in the pre-grant or post-grant opposition. Remember, pre-grant and post-grant opposition has got same kind of grounds, but revocation has extra grounds, and that extra ground is something which is related to section 64 revocation in this particular case. And those extra grounds you have a hint actually now what would be those grounds under which the opponent can actually file revocation. And how I can avoid this? The answer is very simple. In case of if you have gone through the amendment of patent, actually you can do it under section form 13 with the prescribed fees to include Q actually to avoid the revocation. See, there is no question of infringement or non-infringement here. There is definitely a infringement as long as the information is given. Now, assume that X invention has not been patented but is merely the subject of patent application. It's not granted basically, it's a application. Now in that case, if application is published, the patentee cannot enforce the rights as the patent is not granted yet. The patentee cannot enforce because the rights would be from the day of publication, but you can enforce the rights only when the patent is granted. The rights you can enforce only after it is granted. Now, what if the application, so in that case, of course, what you can do is you can include that limitation of catalyst Q at any point of time, at whatever stage your application is, in the FER reply, at the time of hearing, written submissions, or a voluntary amendment, you can include Q so that your case is stronger now and there is no chance of revocation. If application is not published, then exactly same thing. You can actually change the claims at any point of time. But what would I recommend actually to the applicant also is file form 9 for early publication, because you know that the rights would be from the day the patent is actually, the application is actually published. Now, this is the real answer for this. Now, you have to mention about the infringement, for the first question. Second, you have to mention about the revocation and form 13. Third, you have to, for the second question, you have to distinguish between application is published and not published. In not published, you can include the early publication request under form 9 actually. Now, it indicates that X addition of the cat. I think each one of you, most of you got this information that this can be under patent of addition actually. So if you are having a patent of addition, then in that case actually, the improvement can be actually covered under the patent of addition. That's the advice I would give as a patent agent to the applicant, that the catalyst is an improvement. So we file basically a patent of addition under section 54. This won't get granted before the grant of the main invention, first thing, and this would protect your invention, although the main invention, if at all, gets revoked. ये भी आपको mention करना है, because this is also important as far as the patent of addition is concerned. Let me take a couple of questions that I have got here. I have got a question from Rajita here. Could you explain what is SCR in Ericsson versus Union of India? Rajita, the SCR is available on the patent office website. You can check it through. Actually, even recently we got a SCR. Subsequent examination report comes if you are as a patent agent, your arguments for FER are not persuasive. Instead of going for the hearing, or for example, there are 5 objections in case of FER, and you reply to all 5 objections basically, but then for all 5 the controller is not satisfied, then he can come up with a SCR instead of going for a hearing. If the number of objections reduce, he can or she can go for the hearing. I mean, that's not the rule, but then that's what the practice is, I believe. Yeah. Harita, if granted patent means patent application is published and information in description is in public domain, can this be one of the contesting points? No, Harita, I think there is some mismatch in the question actually. Like, once the application gets published, everything is in public domain, and based on that information only, I believe the applicant basically, the infringer basically, the competitor use that particular, I would say, the process basically. So it was in public domain basically. Okay, 3 parts, 6 things to be mentioned here, and full 10 marks. But I'll tell you what, in 2022, after 12 years, this question has been something I discussed today with 2 or 3 patent agents. Everyone on the first go mentioned that the product is infringing. The infringement is always based on what is there in the product, the infringing product. What is there in your claim? A, B, C, specified conditions. If all these 4 elements are present in the infringing product or process, the patent is getting infringed for sure. Whatever 100 things you add, catalyst you add anything in that, it would be infringing only. Right now I also have can the patentee say that the invention is in public domain? Yeah, but then that's how it is. No, it is there in the public domain. No? So what's wrong with it? Oh, of course, once it is in public domain, actually, I would say, the application is published, it's in public domain, basically, right? Now, so that's about an interesting case. Actually, the key message herein I had to give you is read every line carefully. In this case, every line had a meaning associated with it. There was a hint given. The moment actually when I started reading it, I thought of the question was misleading. December 2009, January 2010, I can go for post-grant opposition. That is allowed as a competitor, but the ground is not available in post-grant. So you'll have to go to revocation actually, right? The Q part is given to divert your mind from that infringement thing. Based on Q, would it be infringing or not? And this Q actually was a key thing here. Q would have been helpful for revocation. but not at all for infringement. For the burden of proof when it is on the defendant, basically. So once a case is filed, in that case, once a case is filed, once the case is filed, actually, in that case, the defendant जिसके against case file हुआ है, he'll have to prove that his process is non-infringing. I've got a question here from Rachna. Will addition of catalyst not change the scope of claims after grant? Yes, it would change. The addition of catalyst would change the scope, but it would be not under attack under revocation then. That is first thing, Rachna. Second thing is that still because the question mentioned is that the competitor of ours has been using the process. Using the process means what? Is it using Q or no? Not that we don't know. What are we presuming? It may reduce the scope of the invention, is absolutely fine, but it would help you. It would help you actually. It would help you actually to in case of ensuring that आपका patent revoke नहीं हो रहा actually, because that is more important. Now Yogita has a question: what is the condition for post grant opposition? I mean, why that is not used? So Yogita, that Dr. Yogita, this is something जो grounds for revocation and grounds for opposition, just compare. Remember that one pura chart tha jahan pe grounds of revocation which are different from oppositions we had discussed specifically. Okay, so that is something. So there has to be a ground available. So for example, industrial applicability is not a ground for it's not a ground for opposition. Based on industrial applicability, I cannot file a pre-grant or a post-grant opposition actually, but I can file a revocation. Revocation का वो ground है. The grounds in revocation are more than pre-grant and post-grant opposition. ये चीज check कीजिए आप योग्यता. That's how it would be answered. I have this last case. I'm from pharma and compulsory licensing is something which has been a key issue globally. And as a pharmacist, I always felt what are those things actually which are specific to pharma, which I can focus on as an individual actually while reading. And then I always have this section 3D, the Novartis versus Union of India. I'm not going to discuss today. Maybe some other time I'll discuss it. But the next thing is compulsory license. Very interesting case. Before I actually move on, I think I must take this opportunity to thank one of my friends, close friends, and I would say who worked with me for a long time actually, Miss Mitali Bhagwat. She had prepared all these slides for compulsory licensing 5 years back when she was working with me. Now, section 84, compulsory license. Very interesting. People come to me and ask, what is the difference between normal licensing and compulsory license? As the word says, voluntary licensing is something wherein the applicant is giving the license. Compulsory licensing is something wherein the government is forcing you to give the license to the third party. But then there are conditions. Section 84 we'll discuss all these three conditions in details actually. There was only one compulsory license till date that has been awarded in India, and that case we are discussing it actually today. Once a patent is granted, after that within 3 years, after the expiry of 3 years, basically you can apply. Any person interested, that means any party who has the capability to manufacture or who is interested in that invention, may make an application to the controller for grant of compulsory license on patent of any of the ground actually. So there are 3 basic grounds. Reasonable requirement of the public with respect to invention has not been satisfied. Matlab, there is a requirement for the product in the market, but they are not in a position to fulfill that requirement. Secondly, the invention is not available to the public at a reasonably affordable price. Thirdly, the invention is not worked in the territory of India. Simple lagte hai grounds, right? But then there are three problems with this. What do you mean by reasonable requirement, and how are you going to prove it legally, whether the reasonable requirement, because this is a relative term. The reason, Joe, like claim drafting, we are not allowed to use the relative terms, like, reasonable requirements of the public with respect to the invention have not been satisfied. How are you going to prove the reasonable requirement? That we'll see. Patented invention is not available to the public at a reasonably affordable price. Now, reasonably affordable, something what is affordable to me may not be affordable maybe to someone who is my friend, like, or maybe who is working, or maybe working with a big MNC, let's say. He or she may be ultra super rich to afford it. I can't afford it. What is the definition actually? Not available to the public at a reasonably affordable price. How are you going to prove it? Thirdly, not worked in the territory. What do you mean by not worked within the territory? Is it manufacturing? Is it importing? Is it doing research? What is it actually? And based on these three grounds, actually compulsory. Why I'm discussing this is because I think there have been a lot of questions about compulsory licensing in the previous year's question papers, but there was a specific MCQ as well on this case, as well as this has been also asked in the Viva as well many a time. Now we have this so Yogita, person interested person, I think just you are just rephrasing the words. It should be same actually, right? Now in this case for this particular product of buyer actually, so what happened in this particular case is the first condition was actually met. The first condition, that 3 years had been passed actually. 3 years had been actually passed actually since the patent was granted, and thereafter actually the company Natco Pharma applied for the patent, the compulsory license actually. Now in this case, all they applied, it can be applied on any of the I would say grounds basically, but Natco applied on all the grounds basically. The drug name is Nexavar Sorafenib actually, and the Natco had brilliant submissions actually, because I remember discussing this case in a forum for more than 2 hours actually. This is where a technical person's role come into play actually, or a business person's role come into play. Compulsory licensing is just not technical or legal, it's more of business as well. Now Natco submitted that. Now this was with respect to reasonable requirement, whether it is satisfied or not. Natco submitted, there are 29,000 patients, unko 23,000 bottles chahiye. In 2008, none of them was actually imported. How did they get this data? They get this data from the submissions that were done at the patent office actually by the buyer actually. So commercialization of invention related aapko submissions karne padte hain. Under that, this data was 2008, nothing was actually imported. In 2009, 200 bottles were actually imported. The requirement was 23,000 bottles. Worldwide sales and in availability, the product was approved in US in 2005, launched in 2006, and only availability is only available in metros, that is only with 1% public getting benefited. Maybe someone who is sitting at a very small town in Maharashtra may not have access to it. Also there was another infringing party, Cipla, who was selling the product. Now in this case we'll discuss this, how Cipla is relevant here. Buyer submitted that number of cancer patients were 8,842, because for these kidney patients. Basically, there were alternative treatments available. Then presence of CIPLA, hence unable to work the invention to the fullest. Like, now the problem with Bayer is that they have filed a lawsuit against CIPLA because they are infringing. But herein they are saying CIPLA bech raha hai, CIPLA is selling, that's the reason public's requirements are fulfilled. Sales by CIPLA and Bayer together, considering the reasonable requirement of public, is actually getting fulfilled. Very interesting. Ye doglapan hai, right? Now, those were the submissions by Bayer. So that doglapan comment was coming from Shark Tank India, actually, like, what controller? So this compulsory licensing happens at the patent office. What controller said? The controller found the merit in NATCO's submissions. And according to Form 27 submitted by Bayer, only 2% of the, only an insignificant quantity was imported. Only 2% of the eligible patients are receiving the drug. The patentee's conduct is not justifiable. Agrees with the applicant that Bayer has filed an infringement lawsuit, so CIPLA's sales should not be taken into consideration while considering the reasonable requirement. Actually, agar reasonable requirement consider karna hai, to CIPLA's presence should not be taken into consideration, because reasonable requirement has to be fulfilled by the patentee as per the compulsory license. This was about the first one. Now the next one is a reasonably affordable price. Now the condition is that price is too high. 2,80,000 is the price that NATCO, the patentees, Bayer was selling the product at, and the NATCO submitted, like, some papers about affordability of medicine in developing country. Only interest of public should be taken into consideration. Actually, those were NATCO's submission. What Bayer submitted. And as a pharma scientist, those of you who are from pharma industry who have joined in for the session, for the pharma scientist, we know that one drug comes after 10,000 failure. The cost has to cover previous R&D failed trials. That's the reason my price is so high. Now, the distinction should be made between different classes of society and their power to pay. What I mentioned, the friend of mine who is working with a global MNC, for them, the pricing affordability is different. For me, sitting in a small town, the pricing affordability is different. I can't afford those things. Now, Bayer also submitted to take into consideration CIPLA's pricing, but so Bayer was banking more on an infringer's point of view to avoid the compulsory license here. Controller said that the price is high, basically not brought to the public due to its high price actually. So like, the price is really very high. Agrees with the patentee on this, that reasonably affordable price actually has to be, the term is different for everyone. But patentee has not executed any differential pricing. If you are so much bothered, if you feel the affordability clause for me and my friend who is working with a global MNC, okay, the pricing is different, keep a differential pricing. Why are you not doing that? And CIPLA pricing is meaningless as far as the reasonable affordable pricing actually is concerned. So if you look at the kind of data that is getting generated here, the kind of competitive intelligence or business intelligence NATCO has done was really wonderful to understand each of the clause. And I'll tell you what, as an organization, Patlex Business Solutions, we have been involved into these activities of competitive intelligence. I'll tell you, IP patent, especially in the context of pharma nowadays, has to be in sync with business. Then only it makes real sense. And these kind of cases are, I would say, an eye-opener for those patent agents or aspirants who are looking forward to career in patents, basically in the life sciences industry. Third clause, section 84 1C, that not worked within the territory of India. NATCO submitted that. NATCO submitted that. It's like, they have a lot of manufacturing capabilities in India, facilities in India. Still, they are importing it. Still, they are importing it. Now, what buyer submitted, working does not necessarily mean manufacturing in the country. In fact, as per TRIPS Article 27.1, local manufacturing is not mandatory. That's what buyer submitted. Nexavar is required in very small volume, so it's a strategic decision to import it basically. Controller. Now, this was something which was, I think, can be debatable, but controller agreed on NATCO's submission that it has to be manufactured in India. But remember, this is in case of compulsory licensing. There has not been a second case of grant of compulsory licensing. There were two or three applications, but those were withdrawn later. Patentee fails to manufacture. That's the reason the compulsory license is awarded. And what are the conditions actually? The conditions actually are included here. The pricing is almost 8,900 rupees for 120 tablets within the jurisdiction of India. A buyer would get a royalty. Remember, although it's a forced license, the NATCO would have to pay the royalty actually to buyer. NATCO would have to pay the royalty. Buyer asked for 15%, controller said 6%. NATCO was willing to give as per the controller's requirement. And controller also said that product will be given to 600 needy and deserving patients per year. Now, buyer also tried to think about the business, and this has to be non-exclusive, non-transferable. This was fine. A controller also said that NATCO cannot out-license the manufacturing. They have to manufacture at their own facility. No import, or else NATCO would import it from outside. Because the major concern in this product, this is an anti-cancer actually, sorafenib. In this product is the volumes are very less. Manufacturing at a R&D level is at the plant level, maybe really, I would say, because of the quantity. And since it's an anti-cancer, you need a separate onco facility for that. Now, buyer, submitted that no right to represent publicly or privately that NATCO's product is same as that of patentee. They are focusing on the brand value, brand association basically for that. And applicant and patentee's product should be visibly distinct. And for both the things, controller actually agreed on this particular year. And so this was that unique case wherein the CL compulsory license was actually granted. There are a lot of other conditions. I think we won't go through these conditions because we have already overshoot the time. But then, go through this case. I'll share this case. Of course, the video would also be available at least for another 2 or 3 hours. Thereafter, this video may not be available. Now, you go through this case. Very interesting case, and especially if you are from life sciences, pharma se ho, biotech se ho, food tech se ho, botany se ho, zoology se ho, go through this case. Wonderful case. You would have a lot of learning, insights of combination of law, business, and the patent, basically, the technology, basically. Okay, that's my suggestion. The conclusion was that there was a first compulsory license which was actually given to NATCO for Nexavar, sorafenib, and the patent was for buyer actually. Now, that's what I have actually for you, all of you, for the day actually. And these cases I wanted to discuss just to give you an idea. I also have to mention here in that, we are more than halfway now. We need that momentum or tempo to be continued till end. And that's the reason, because there are a lot of students from previous batches of our classes. For them, we have come up with this new year. We would be giving access to all our videos, 1 to 20, all sessions actually. You can appear for mock test papers 1 to 5, although you are not our student, basically. You would also be getting an access to ebook on patent drafting with different kind of claim formats, actually. That is also something we are doing. If you are looking forward to this, just get in touch with me. My number is mentioned, and my number is also, I would say, always available with, if you just Google, you would get my number. Thank you so much on joining on this, I would say, wonderful evening on an auspicious day. Happy Mahashivratri, and I'll look forward to see or discuss with all of you different case studies on this particular platform. Again, I'll be coming, and since this is the first technical session, like I would say, I would also be looking forward to your feedback. You can put it in the chat box. If you like the session, put it in the chat box actually, as well as you can share this as well. Thank you, everyone.